by setting out, Your Ladyship, the documents that we have filed for the record. We have filed submissions date.
Incidentally, Professor, we have the ball.
Yes.
We also risk them.
Yes, it's okay, Your Ladyship. I
We
will.
also go through that task of risking them before the hearing.
Yes.
So if you can save your time.
Yes, I will go right to the questions, Your Ladyship. Your
With your
Ladyship.
kind permission, my lady, with your kind
Yes.
permission, it seems that amply Professor has left out my name.
Sorry, Mr. Ian Wambua, sorry. Your Ladyship, I wanted to just deal with that Mr. Ian Wambua Mbithi is holding brief for Mr. Omogeni, Senior Counsel, who is involved in other Senate business and therefore will not be here. So just
So
for,
this
yes,
is here.
Wambua Mbithi.
Thank you very much. So you have the 20 minutes.
Yes.
Starting now.
Yes, Your Ladyship, this appeal originated from the High Court. And the initial High Court petition, Your Ladyship, was Constitutional Petition number 284 of 2019, which dealt with, amongst others, Your Ladyship, the interpretation of the powers of the Speakers of Parliament under Article 110, Sub-Article 3 of the Constitution, read together, Your Ladyship, with the powers of the National Assembly under Article 95 and the powers of Senate under Article 96. All must be read together. Your Ladyship, this commenced as a constitutional question, and I'm submitting this, Your Ladyship, so that the question of jurisdiction peradventure would be a matter that I need not argue before this court. I therefore will not need to cite Lawrence Dutu and that other long line of cases on jurisdiction, because this court has jurisdiction to entertain this appeal under Article 163 3A. Your Ladyship, the initial successful petition at the High Court led to the declaration of unconstitutionality of 24 statutes enacted by the National Assembly without following the mandatory requirement of a meeting of the speakers on the bills. Article 110, Sub-Article 3, Your Ladyship, provides that before any bill is brought to the House, the speakers of the National Assembly and the Senate shall jointly resolve any question as to whether it is a bill concerning counties. And if it is, Your Ladyship, whether it is a special or an ordinary bill. The contention and what has led us to where we are was that these 24 bills that led to the initial course of action did not go through the mandatory requirement of Article 110, Sub-Article 3. We will argue, Your Ladyship, that not only did the Speaker of the National Assembly ignore the provision of the Constitution, but the Speaker of the National Assembly, Your Ladyship, also ignored the decision of this court in Supreme Court Advisory Opinion number 2 of 2013 in the matter of the Speaker of Senate, which was a decision that was available for consultation by the Speaker at the time these 24 bills were processed. In the end, Your Ladyship, our petition prays that the misdirection by the Court of Appeal, Judges Murgor, Judges Pauline Yamwe, and Judges Lesit, that proceeded to apply to set aside the decision of the High Court, be set aside. And in place thereof, Your Ladyship, this court upholds the decision of the High Court. Your Ladyship, in the 12th Parliament, at the time of the filing of the petition of appeal, we submit that it was deliberate on the part of the Speaker of the National Assembly to proceed to consider bills whilst ignoring what Article 110.3 sets out. And we refer the court to Volume 5, Paragraph 443, and Volume 16, pages 2019 to 2017, on that question, Your Ladyship. Your Ladyship, concurrently, we are aware that the Council of Governors also filed another petition that were all consolidated and that have led us to where we are. Your Ladyship, we submit that the Court of Appeal, whilst there was a cross petition, found, and we submit, that any bill which has not been subjected to concurrence envisaged by Article 123, first of all, my Lord, Your Lordship, must be found to be unconstitutional. Because applying the purposive approach to constitutional interpretation, the people, while crafting the Constitution, intended that Article 110.3 is given primacy and is the very foundation from which all the other articles defining money bills and ordinary